Moving right along, next we're going to talk about Florida's Construction Defect Statute, Chapter 558. I remember a time when this statute was not in effect. Just a little side commentary before I get into it. This statute has been around for quite a few years, and the intention of the statute, I think, is laudable. I think the legislature was concerned with what it perceived as a tremendous amount of condominium lawsuits. Typically what happened is, your condominium turns over, the association hires an engineer that does a turnover inspection, and invariably they come up with this, this turnover report from A to Z that has every little failure to meet plans and specifications, and right away the condominium association will go out and hire a lawyer and sue the developer and everybody else. And so Chapter 558 was as an attempt to curtail that litigation, and really what it provided for then, and it's been modified several times since its inception, and I'm going to go over the most recent version of it right now, but really the rationale behind the statute was, before you can run into court and sue, let's give the folks involved in the construction work, could be the design, could be the architect or engineer, let's give them written notice of the defect. Let's give them an opportunity to inspect that defect. And who knows, they may even offer to fix it free of charge to the owner. Or they may offer to pay money. And if they do that, and that's acceptable to the owner, now you've avoided litigation. That's not good for the lawyers who bring and defend those claims, but it's certainly good for the parties because they're able to come to a resolution before running into court and spending a lot of money litigating these cases. And these defect claims are very, very, very costly. And so that was the goal behind Chapter 558. Now, initially when the statute was enacted, it only applied to residential dwellings. That since has been expanded to involve residential and commercial projects alike. And like I said, the goal was to provide notice and opportunity to cure and settle construction defect claims before they found their way into our clogged court system. Particularly now we've got all these foreclosure cases in Florida. I'm sure that's unfortunately what's happening around the country. Our court systems are so clogged, but at least with construction defect claims, we have the opportunity to avoid the courtroom ahead of time. So you have to provide notice and opportunity to cure or settle the construction defects, and the notice, the statute says the notice must describe the claim in reasonable detail, whatever that means. Although if it's sufficient to determine the general nature of the defect and a description of the damage or loss resulting from it, if known. And that's 558.004. Typically, I think what you see happen is if you're dealing with a condominium, it doesn't have to be a condominium, but if you're dealing with a condominium, Chapter 718 and the law interpreting that requires that the turnover report be done by a licensed engineer or licensed design professional. And so typically what you'll see is, and if I represented a condominium association and I'm sending out a Chapter 558 notice, I'll simply just attach the turnover report to a cover letter, and I'll send that off to whoever it may be, whether it's the developer or the contractor or subcontractor, whoever I'm intending to sue. I'll just attach the turnover report because that's a lot easier than me just regurgitating everything in the report. And generally, those are very, very in-depth. So, of course, I think that would meet the reasonable detail standard under the statute. The statute is not applicable to claims for personal injuries. So, if you have a claim for personal injury that arises out of a defect, then you don't have to apply the statute to bring that lawsuit. And the notice, tolls the statute of limitations, and that's expressly right under 558.004 and the Salt Ponds condo case that I've cited in the materials. Now, who does the statute apply to in terms of bringing an ultimate defect claim? The statute uses the word claimant, and that's defined as a property owner, including a subsequent purchaser association, who asserts a claim for damages against contractor, subcontractor, supplier, design professional. So basically anybody that you're intending to sue. I'm not necessarily suggesting you have to sue anyone other than the developer or the contractor. But if you're intending to bring a separate action, perhaps for negligence, against a subcontractor or a material supplier, then statute says before you do that, you do have to send out a 558 notice. And statute says that a claimant does not include a contractor or a subcontractor or supplier or design professional. So really, it's the owner of the property that's going to bring that claim. And so if a contractor is going to make a cross-claim against another party, another subcontractor, or is going to make a claim against a design professional, then they don't fall into the definition of claimant, and so they don't have to send out this 558 notice. And it also does not include an owner who is also a contractor. Sometimes you have a GC that happens to own the land, and then also is a general contractor. And special engineering case said, no, we're not going to find claimant. We're not going to define claimant as involving someone who both owns the property and is the general contractor. What I often see happen, and the statute allows for this, is downstream notices. That's a term I like to use, and a lot of lawyers that deal with the statute call them downstream notices. And so even though a contractor, subcontractor, or supplier is not a claimant, what will typically happen is when they get a 558 notice from an owner, they will then send either a copy of it or they'll send their own notice. They're not required to do it, but they can send their own notice to somebody under them who may be responsible for the defect. So the GC, general contractor, gets a 558 notice. He will ultimately and likely send a notice to all his subcontractors who may have provided the defective work that's the subject of the 558 notice or the turnover report. And so when the contractor or whomever gets the 558 notice gets that, the statute allows them to conduct a reasonable inspection, and that includes destructive testing, and that's under 558.004 sub 7. And generally on these larger, I'll say condominium cases where you've got a lot of parties, you've got the developer, general contractor, you've got all the subcontractors, you can have a very large 558 process. And I've been involved in some that have taken as much as a year before we even filed our lawsuit when we couldn't get the resolution for the association that we wanted. But destructive testing is permitted under the statute, and it obviously should and needs to be coordinated with the parties involved. And the requirement under the statute is that whoever's doing the destructive testing has to restore it. They can't just kind of like leave a hole in the wall. And I like this part, no lien rights. You know, if you go out and anybody that deals with lien claims, you're allowed to lien for quote-unquote improvements to real property. Well, improvements can be demolition work. And so if you've done demolition work, you can lien for those services. And so, but if you're under a 558 notice and you go out and you do demolition work and you're not paid for it, then you can't lien the owner for that. So that's the exception there. So you don't get lien rights. Now, if the owner fails to allow for destructive testing, that can negate a claim for damages if the destructive testing could have avoided or mitigated the damages. So if the owner had allowed the destructive testing and you go along further in the process and ultimately perhaps maybe the claim might have been resolved had the owner allowed the destructive testing, the owner says no, then the statute says that will negate maybe not the entire claim, but any part of the claim that may have been avoided or mitigated had the owner allowed destructive testing. The statute also allows for certain pre-suit discovery among the parties receiving a notice and the claimant, and that even includes exchange of expert reports. That's under 558.004 sub 15. Now, the party receiving the original notice is required to provide a written response to the claimant. So, of course, the claimant is probably the owner, and you are required to provide a written response. And by the way, the statute, for those of you who are familiar with it, you know this. For those of you who aren't familiar with it, there are deadlines and time frames in the statute that tell you how much time you have to to provide a response to the 558 notice. But the party receiving the notice has to provide a written response to the claimant that either contains an offer to repair the property, or pay a sum, or both, or disputes the claim. So the contractor can either say, I'm going to, or it could be the subcontractor, whoever gets the notice, I'm either going to repair this, and it won't cost you a thing. I'll do it, I'll do it at my expense. I'm either going to offer you a sum of money because I don't really want to come back on your property. I'd rather pay you a sum of money, or it could be a combination of the both. Or the party receiving the notice can just say, I've gotten your notice, thanks but no thanks. I'm disputing I have any liability whatsoever, and I'm not intending to offer you any money, and I'm not intending you to do any to pay you any money or make any repairs. Okay, and so really the purpose of that is so that the owner has the ability to know whether or not this person receiving the notice is going to either dispute the claim or is going to make some sort of offer, and whether it's repairing it or paying some sum of money. And of course, if the party receiving the notice disputes the claim or says, I'm not going to do anything at this point, now the owner has complied with the notice provision of the statute and can basically go after that party without further notice. The owner has now complied with 558. And a claimant who receives timely notice of an offer must timely either accept or reject it in writing. So if the owner gets some sort of offer, either it's money or repair, and they're not satisfied with that, sometimes they are, sometimes they're not, but if they're not satisfied, they have to reject it in writing before they can go to court and then file their lawsuit. And the statute does allow for partial settlements as well. There's no requirement that you have to settle any portion of the case. Really, this is there's a case, and I can't remember the name of the case. Might have been the Banner Supply case. There's a case that I'll get to it later. There's a case that deals with 558, and you can lead a horse to water, but you can't make the horse drink. Basically, the owner merely needs to comply with the statute, and obviously the person receiving it does as well. And they're not obligated to do anything other than write back to the owner and say, thanks, but no thanks, I'm not going to do anything, or I'm going to make you an offer. And so the owner's either free to accept that offer or not accept the offer. The owner is free to accept part of the offer or not. And of course, if it's partially settled, then obviously that part of the case goes away. But the owner does need to do so in writing. Any offer or failure to offer a repair, a defect, or pay money in response is not an admission of liability and is not admissible in any action. So certainly you're free to accept or reject any offers that are made, and those are not admissible. Of course, if you accept an offer and the parties can enforce that, obviously. But the fact that you rejected an offer in writing is not admissible. So what happens if there is noncompliance with the statute? The statute simply says that the action gets abated or stayed upon motion. And so what will typically happen is the owner of the property will file a lawsuit without complying with 558, and the other side can waive that if they don't want to stop the lawsuit, but they're certainly free to file a motion with the court asking the court to abate the lawsuit until the claimant, generally that's the property owner, has complied with the statute. So if you get a situation where an owner prematurely files suit without complying with 558, then the court, if it finds that the owner hasn't complied, will merely abate the lawsuit, and then the parties are then, go back to complying with the statute. So obviously the owner has to provide a 558 notice if it hasn't already done so already. And then, of course, you get the back and forth with the offers, the acceptance or rejection. You get the inspection process. You get pre-suit discovery. So all of that will then have to go on before you can come back to court and then continue with the lawsuit. So where an action does get abated because of noncompliance, then once the parties go back and comply with all that, and you wind up where the the contractor, whomever, makes an offer that's rejected by an owner, or just simply says, "I'm not going to offer you anything," and the owner rejects that in writing down, you can go back, and you're off to the races again, and you can go back to court. Statute says, before I get to that, the Banner Supply case that I mentioned, the court, I thought this was kind of funny. The contractor in that case, the party in that case tried to invoke the statute well after the lawsuit was filed, and the court basically said, well, basically it would be futile for the court to abate the action where prior to filing the suit, the claimant invited the supplier, in this case it was Banner Supply, I think this was a Chinese drywall case, to inspect the property. So even though there wasn't a technical 558 notice, the purposes of the statute, I think, were fulfilled here because the claimant in this case gave the supplier the opportunity to inspect and essentially did nothing to attempt to conduct the inspection, and then waited for a long time after the case was filed and then moved to abate. And the court said, no, you basically waived the right to invoke the statute at this point. So be mindful of that. So if you're going to invoke the statute as a defendant, you should do it as soon as you can, because obviously if you don't do that under the Banner case, the court may find that you waived it. Okay, moving on. Emergency repairs are okay. So an owner who must make emergency repairs can do so before the 558 notice even goes out, and that's under 558.004. And unless a claimant and a potential defendant have in writing opted out of the statute, which they can do, its procedures apply to any contracts that contain, and if you look at the statute, there are certain cautionary language that needs to be in the contract. So if the contract has that required language, basically telling the parties that 558 applies, and the statute will apply, and it also applies regardless of the notice provision in the statute to any action accruing before 2004, regardless of the language in the statute. And so I always like to err on the side of caution. I'd say most likely the statute does apply, and if you're an owner, assume it applies. And if you happen to know the lawyer on the other side before you file suit, you might just get together with the lawyer and say, hey, do you want to opt out of 558 and let's just go straight to court? And the parties are certainly free to opt out of that. But if they don't opt out and the statute does apply, which likely it does, then again, you've got to comply. And if you don't, then the action will get abated pending compliance, unless of course the court, like in Banner, finds that you've waived 558. The statute does not bar, limit, or create any other rights of actions or theories, nor any defenses except as provided for in the statute. And recently, if you're following new legislation, and by the way, I told you about the Construction Law Committee. There's a legislative subcommittee as part of that committee, and that's a great subcommittee. And the members of the CLC often get little updates on what bills are pending, and that committee does a great job of tracking the bills and letting us know where those are at. And one of the bills that the committee shared with the rest of us is that 558.0035 actually was signed into law by Governor Scott, takes effect in a few days, July 1, 2013, and that will attempt to limit liability for individual design professionals. And I don't know why they put this under 558, but they did, and so there's an additional provision. And you can take a look at the statute, but essentially, if a design professional is working for an entity, and that entity carries certain professional liability insurance or errors and omissions, that the individual, design professional architect is not going to be liable. That you've got to go after the contracting entity. I mean, I personally think this is in response to the Morancis or Morancis, however you want to pronounce it, the Morancis case that found an exception to the economic loss rule. Of course, that's no longer good law, but at the time, which said, notwithstanding that you've got a contract with a professional entity, that you could sue the individual design professional or professional in negligence. This statute now is going to limit your ability to be able to do that. You're going to have to go after the entity assuming that they comply with the statute and assuming that they carry the required insurance. So really, this is really going to make it much more important when you are hiring a design professional, if you're an owner, to make sure your contract requires specific coverages, because you certainly don't want to be in a situation where you're basically going after an assetless or company and you basically have no remedy. You may get a judgment, but you're not going to be able to collect it. One of the things, and this is going to remain to be seen, this struck me as odd when I read this, is that it includes a sole proprietorship or self-employed individual. So the qualified entity that falls under the statute includes a sole proprietorship or self-employed individual. And I thought, well, that makes no sense. So you're saying if I'm not a corporation and I'm, Joe Architect, and I contract directly with an owner, does the statute going to prevent you from suing me? I don't think so. I think the courts are going to interpret this to mean that if it's an entity, that's one thing. But if it's a sole proprietorship or you're self-employed and you provide the service, then, as we all know, if you're a sole proprietorship, you sue the sole proprietor. And so that struck me as sort of odd. So it'll be interesting to see how the courts interpret that, once the statute takes effect.